They tried with some earlier applications, interrogatories. The court didn't uphold that. The court rejected that. They tried to compel her. The court decided on February 11 that it will not allow that. They tried to review that. They asked for a review application. The court dismissed it. They also tried to reopen their case. They filed an application to reopen their case. The court dismissed that as well. And they are filing for a review of that decision. I want to understand this review application, the review application of the February 11 decision, which sought to compel Jean Mensa to testify. Okay. The court's decision against them was that, and I want to just pick a small quote, the petitioner in this application has not given us an inkling of the new or fresh evidence he wants to bring. And they also go out to say they find neither has he disclosed how the evidence will advance the cause of his petitioner. Mm-hmm. So the court is saying that from what we're reading from their ruling is that they've not shown the evidence and how that evidence they want from Jean Mensa will advance the cause of their petition.
Yes.
What is lacking in their supposed evidence?
Okay, so that may be a little difficult, but if I want to take it to why the court made that, or maybe to respond to that ruling. Okay, so definitely in the reopen application, that's how I simplified it. Okay. It was for a purpose, one purpose, and that purpose was to enable the petitioner compel or subpoena the EC chair, okay, to be cross-examined or to testify. Okay, so this is where the court was saying that the ruling actually touched two things. What the requirements or the principle that should govern applications to reopen a case in a civil action. Okay, and then also the court had to also look at whether or not there's a case to subpoena. Okay, so the two, because the purpose of the reopen application was tied to the intention to subpoena the EC chair, the court needed to deal with the two. So you see that the first level, whether or not we can generally allow you to reopen your case when you have voluntarily done so, close your own case, is where you have to tell us that you have discovered new evidence that with due diligence you couldn't have obtained earlier. Okay, so there's a fresh evidence that you want to bring before the court. And then the court is saying that if we permit you to reopen your case, what will you do? You are trying to subpoena. There will be, as the counsel for petitioner is clarified so many times, that there were supposed to be two applications. The first one was the leave or the permission from the court to reopen the case. And then there will be a second one which will be on subpoena specific. To subpoena application to subpoena the chair of the first respondent. Okay, so the court is saying, well, the second bit, first, on the opportunity to reopen your case, you have not demonstrated that you found any new evidence or fresh evidence that will require us to allow that. And then second, you have not also told us, that's in the bit of subpoena, the intention, you have not told us what is it that you want from the EC chair that will help the court to determine the matter or help your case. Okay, so that was the bit that the court hammered, that you have not shown anything at all. Okay, you have not justified why you need the EC chair.
Very well. Without getting myself into any trouble with contempt of court, I just want to find out, so why can't the court then allow the EC chairperson to come into the witness box and then we find out what evidence it is the petitioner wants from her?
You know, the court play its rules, according to the law. Okay, so it's saying that for every application or every step you want to take in a pending matter, these are the requirements to make. If you allow that, because, if the court is to allow this so that you don't even prove anything, let the person go and let's see whether you have. So at the end of the day, if the court did not see or the court doesn't see that, then we would have wasted time and space and all that. That is why the court is saying, justify why we should compel. Because remember, the court has emphasized the autonomy of a person to give evidence. So you can see that subpoena becomes an exception. Remember, it's an invasion of your rights. Earlier in the matter, one of the justices also even raised the matter of human rights, even though that was abandoned at some point. But the whole point is that you have a right to liberty. And so if you want to compel me, then there should be a very strong reason for me to be compelled. So you have to demonstrate that to the court before the court will allow that. So the court will not just say, let's go in and see. No, and then we should also remember that the court is working in accordance with some timelines.
Okay.
Some timelines. And when you allow some of these spaces, you don't know how long it will take you.
Okay. I want to bring in Amarh Addy. And this was an article of yours, not related though, but an article titled, "The Judge Must Uphold the Sanctity of the Law, a Reflection of Family Litigation." That aside, given that you write and you follow the issues, and your background, you have a rich background in education, I want to ask you, as an educationist and as a citizen of Ghana, and this is because of a Vox we played the last time, that suggested that people were not really following and didn't really understand the election petition as it was happening. Perhaps it's a failing on the media. But do you think, at this stage that we've reached, because now the interest is keener, that the average Ghanaian is following and understands what is going on?
Thank you. Yes, you said a rich background in education and in law as well. So, but I
Pardon me for that omission.
Yes, but I decided to take the academic aspect of it rather than the other part.
It's still relevant to our conversation.
Yes, so good. Let me simplify everything that has been said and everything that's going on. I mean, who goes to court? It's an aggrieved person who goes to court. So anytime a person is aggrieved and thinks that he can get justice from the law or from the courts, that aggrieved person goes to court. So in this case, the petitioner, which is NDC, are aggrieved.
No, which is John Mahama.
Yes, which is John Mahama, is aggrieved that we've gone into an election and the outcome of the election is not too happy with. And therefore, the right thing to do is to go to court and seek redress. Who did the aggrieved person took to court? The aggrieved person took two people to court. Number one is the returning officer, and then number two is the president.
Number one is the Electoral Commission.
Yes, the Electoral Commission. Number one is the Electoral Commission, who presided over the election.
Yes.
Yes, and number two is the president. The president, yes. Number one, because it is that institution that presided over the election. Mm-hmm. And number two is a beneficiary of the outcome of what number one did.
Yeah.
Okay, so number one first. So the biggest punch or blow is to the number one, because you oversaw everything, and therefore you are able to tell us what went in for number two to have benefited. Okay, so that's what it is. And the issues to be determined by the courts were laid out. Okay, and in our practice, we say that, I mean, the common law as we practice, we say that he who alleges must prove. And therefore, if you are saying that number one has not done something well, it means that you have something which you are referring to say that number one has not done something well, for which reason number two has benefited unduly, as they say. Okay, so therefore show us what you have. And that became an issue. That became an issue. And as we sit now, we have not been shown anything clearly on paper. I mean, we say that the law is about evidence, and the evidence must be documentary evidence rather than the oral, even though the orals are taken sometimes. But in this case, they are documentary evidence to prove. And the aggrieved party has not shown us that.